some internal arrangements between the local presenters about.
Уважаемые коллеги, доброе утро, всех приветствую еще раз. Меня зовут Мадина, представляю общественное объединение Kazakhstan. Благодарю за то, что подключились, проявили интерес к нашему мероприятию. Заранее обговорю, что у нас сейчас ведется запись в Zoom и ведется прямая трансляция в Facebook, поэтому если кому нужно будет ознакомиться с записью после мероприятия, можете это сделать на нашей страничке в Facebook. Ссылку я оставлю чуть позже в чате. У нас сегодня здесь предусмотрено выступление спикера на английском языке, поэтому у нас здесь доступен синхронный перевод. В нижней панели Zoom есть значок глобуса, вот там вы можете перевод переключить с русского на английский, с английского на русский. Итак, сегодня мы проводим презентацию анализа законодательства Республики Казахстан, препятствующего правозащитной деятельности. Почему мы, в принципе, проводим такое мероприятие и проводим анализ законодательства? Потому что до сих пор по сей день существует тенденция в отношении правозащитников, гражданских активистов, еще имеют место быть большое количество угроз в отношении правозащитников, гражданских активистов. Точную сумму мы дадим в наших социальных сетях, поскольку вы знаете, что наша организация «Общественное объединение Kazakhstan» занимается мониторингом ситуации с безопасностью правозащитников и гражданских активистов. Сегодняшнее мероприятие мы проводим совместно с организацией International Service for Human Rights. Сегодня мы хотим презентовать анализ законодательства. Также хотела немного информировать о том, что имеется разработанный проект закона о национальном механизме защиты правозащитников, который является целью создания коалиции в декабре месяце по данному механизму. Проект данного закона он будет презентован нами чуть позже. Просто хочу информировать о том, что работа по разработке такого проекта закона, она ведется. Сегодня наша программа состоит из выступления спикеров, а именно следующее слово я чуть позже передам Тесс МакКевой. Это содиректор и юрисконсульт Нью-Йоркского офиса организации International Service for Human Rights. Тесс нам расскажет о модельном законе о национальном механизме защиты правозащитников, практике изменения правового поля для защиты правозащитников и почему это предпринимают государства. Также у нас предусмотрено выступление адвоката, эксперта проекта общественного объединения Kazakhstan Елены Жигаленок, которая расскажет нам о самом проекте закона о правозащитниках. Также чуть позже ожидается выступление Евгения Александровича Жовтис, который нам представит анализ законодательства, препятствующего правозащитной деятельности. А также есть несколько выступлений от Калеевой Тамары, президента общественного фонда «Адельсюз», Алишера Кожагулова, общественный фонд, фонд развития парламентаризма, Алексей Башков, общественное объединение «Право и справедливость», и Сергей Молчанов, общественный фонд «Доктор СН». Попрошу участников отключить свой звук, пока у вас не появятся вопросы или комментарии, когда мы перейдем к сессии обсуждения. И также еще раз хочу напомнить про перевод синхронный, который у нас доступен. Итак, перейдем уже к выступлениям самих спикеров. И, пожалуйста, следующее слово передаю Тесс МакКевой. Тесс, как вы нас слышите? Да. Угу.
Yes, I hear you. Do you hear me okay?
Да, все отлично.
Okay, great, thank you. So, good morning, everyone. I am Tess McAvoy. As Madina has said, I am from the International Service for Human Rights. We're an international non-government organization dedicated to the promotion and protection of the rights of human rights defenders. And I'm a director and legal counsel and lead our work on legislative protection for human rights defenders. So I wanted to open up the discussion with just some developments internationally and a conversation on what we mean when we're talking about legislative protection for human rights defenders. So, you know, we would all agree that human rights defenders are essential in upholding human rights, in promoting democracy and sustainable development and respect for the rule of law. But despite that, as has been mentioned, as will be discussed further, they suffer from threats, restrictions, and attacks. And restrictive laws and norms can also hinder and impair their work. Some UN experts have, analysed and outlined elements that are necessary for defenders to be able to operate in a safe and enabling environment. The UN Special Rapporteur on Human Rights Defenders has outlined these, and they include a conducive legal, institutional, and administrative framework, a fight against impunity and access to justice around violations against defenders, strong and independent and effective national human rights institutions, effective protection policies and mechanisms, non-state actors respecting the work of defenders, and a safe and open access to UN. And so today we're really going to focus on the element on legislative protection for human rights defenders, the extent to which human rights defenders' rights are protected in both national law and policy. The legal recognition and protection of defenders is crucial to ensuring that they can work in a safe, supporting environment and be free from attacks, reprisals, and unreasonable restrictions. The legal recognition and protection of defenders also contributes to the broader goals of upholding human rights and the rule of law. In 1998, the UN General Assembly adopted by consensus, so all states agreeing to the terms, what's called the UN Declaration on Human Rights Defenders. And this, along with other international covenants, it forms a basis in international law for the protection of human rights defenders. The UN Declaration on Human Rights Defenders articulates a series of principles and rights as they apply to human rights defenders. And in recent years, a wide range of UN experts and mechanisms, including the UN Special Procedures, treaty bodies, Human Rights Council, and the Office of the High Commissioner for Human Rights, together with various regional human rights bodies and experts, have called on states to implement and explicitly guarantee the rights that are affirmed in the UN Declaration on Human Rights Defenders at the national level. They've called on states to review and amend laws which restrict, stigmatize, or criminalize the work of defenders. For example, those that restrict the right to associate or to receive funding. But despite these calls from UN human rights experts, only a few states have incorporated the UN Declaration on Human Rights Defenders comprehensively into national law. And many states continue to implement legislation which restricts the exercise of fundamental rights and freedoms by human rights defenders and restricts them from carrying out their legitimate work. So within this context, there have been enhanced demand to strengthen national legislative protection for defenders, and human rights defenders and community-based organizations in a growing number of jurisdictions have worked on strategies and campaigns to strengthen legislative frameworks at the national level in which they operate so that they can better protect their rights and so that they can protect themselves from the attacks and targeting. In regards to the legal framework for the protection of defenders, as well as looking at ways to strengthen the protection of rights, it's also critical that other laws that restrict the rights of defenders are reviewed and amended. So that's why this discussion today is so important, and why the analysis that's being prepared is so critical, because this process of looking at legislative protection is wider than just one law for the protection of defenders. It requires an analysis of the entire legal framework to get a sense of where the rights of defenders are protected and where they are restricted. In terms of developments at the international level, defender protection mechanisms were first established in Colombia and Brazil in the 90s. More recently in Africa, the Ivory Coast, Burkina Faso, and Mali have adopted laws. as well as in Latin America, in Honduras, Mexico, and Peru. They've all adopted laws for the protection of human rights defenders. And within the Asian region, draft law was recently passed just a week or so ago at the lower house in the Philippines and is currently before the upper house, the Senate. And last year, a human rights defender protection law was passed in Mongolia. There are also current civil society discussions and initiatives happening across various countries, including in Guinea, Sierra Leone, Togo, Benin, Central African Republic, Uganda, South Africa, Paraguay, El Salvador, Nepal, and Fiji. So the reason what my organization does in this work and the reason why we do this work is that we developed what you would have seen in the agenda for today, what's referred to as the model law. And so to assist with the development of laws and policies for the protection of human rights defenders, my organization developed a model law on the recognition and protection of human rights defenders. The model law is intended to guide states and other actors to ensure the full and effective implementation of the UN Declaration on Human Rights Defenders at the national level. It was developed by ISHR over a 3-year period, and we had a comparative legal research study done. We then did consultations with over 500 human rights defenders from over 110 states from all regions of the world. And then we drafted the model law with 28 high-level human rights experts and jurists and an international law firm. So in this context, the model law provides 3 objectives: to assist and provide guidance to states to develop laws, policies, and institutions at the national level to support the work of defenders and protect them from reprisals, to provide a tool for defenders who are advocating for stronger legal recognition and protection, and to provide both states and defenders with a tool against which to measure and assess the coverage of their existing laws and policies. Essentially what the model law, it seeks to provide the high watermark of legal standards in defender protection. And we've worked with with national partners from over a dozen countries towards strengthening legislative protection for defenders. In our experience, there's several elements that are essential for any instrument for the protection of defenders, including that it ensures that it is developed in close consultation with civil society, enjoys high-level political support, does not seek to impose responsibilities or restrictions on human rights defenders. It contains provisions that recognize and respond to particular risks or vulnerabilities and protection needs, that articulates obligations on states and non-state actors, and that it also contains enforcement, penalty, and remedy provisions, and that protection mechanisms should be adequately resourced and include defenders in governance and decision-making. So as human rights defenders serve and pursue the interests of right holders, victims of violations, and society, states then have a primary responsibility to ensure that defenders are able to conduct their work freely and in a safe environment. So what the model law does is it sets out some kind of key rights for human rights defenders, as well as some key responsibilities of states. It says that there are rights of defenders that must be protected to do their work, such as the right to association, to seek information, to communicate with the UN, the right to expression, that there should be responsibilities on states to protect the rights of defenders, to facilitate their work and protect them from reprisals, and that it must not limit defenders in doing so. So I don't want to spend too much time discussing this further, but just to kind of provide that basic outline on what we mean when we're talking about legislative protection, the move and the focus we're seeing right now internationally on laws to protect defenders, as well as on ways in which other laws that restrict defenders should be amended or revised to ensure that they can protect defenders' rights so that defenders can continue to conduct their work. I will stay here for the remainder of the discussion and happy to come in at any other point as well. Thank you everyone for your attention.
Спасибо большое, Тесс.
Thank you so much, Tess.
Я хотела сказать
I
участникам,
would love to
после
mention
каждой
to our
сессии
participants that after each session,
вопросов и ответов
we can organize a question and answer session.
вопросы, которые вы уже
So you can
поэтому
put
можете
down your question that you will raise and you can remember them this way, or you can type them in the chat immediately.
Пожалуйста, если вопросы, можете задать их
If you
сейчас.
have any burning questions now, you can raise them right away.
Так, вопросов пока нет.
I don't see any
Вопросы, пожалуйста, поднимите
issues
руку.
and questions. Should you have, just raise your hand.
Следующее
During
слово
the
я
next
передам для...
presentation, and we see
Сейчас, извините, вижу вопрос в
a
чате.
question in the chat box.
Тесс, я могу вам зачитать
Tess,
вопрос, чтобы...
I will read the question to you.
Вопрос от Сергея
The
Соляника.
question from Sergei Solyanik.
Почему именно в перечислении
Why
принят такой
the countries you have mentioned,
ситуации с правами?
this law has been adopted? Is the human rights situation is really poor in these countries?
That's a really good question. And it's a whole different range of scenarios. So what UN experts are saying is that it's not just in countries where their environment for human rights defenders is very restricted or very bad, where legislative protection is key for defenders, that in every country it's necessary that defenders can have their rights protected within law. And the way that shapes itself doesn't need to be necessarily a specific law. It can be across various different kinds of laws. In certain national situations, it's a protection mechanism instead. And so the shape that these instruments take at the national level depends on the national context. But it's essential that in every country, defenders have their rights protected in national law and in national legal frameworks.
Спасибо большое, Тесс, за ответ.
Thank you so much for your question.
Так, здесь также поступила просьба от
We
Илана
also see a request from
развития. По вашему запросу мы вам
another participant from Irlan Rakishev. Can we receive a copy of the model law for our internal review?
Yes, and there is, so I can send you a link in the chat here to the model law in various different languages, including in Russian, that has been translated by your partners.
Спасибо большое. Итак, мы перейдем к выступлению.
And now let's start with the next presenter.
Закона о защите правозащитников. И следующее слово хочу передать адвокату Елене.
I'll give the floor to Ms. Елена Жигаленок to describe the draft law on the protection of human rights defenders. Good afternoon, dear colleagues. Can you hear me? Yes, we can hear you very well. I would love to make a short overview, or I would rather brief you on what is already available, what is there in place in our country. It is a draft law of Kazakhstan on the recognition and protection of human rights defenders. So why, in the title, you can see the word recognition. This law presumes recognition by the state actors, the presence, the existence of the civic activists, and the need for the protection of their rights. The draft law is based on the model draft law on the recognition and protection of human rights defenders that has been drafted by the group of international experts, and it was adopted back in May 2016 in Switzerland. The draft law is based on the declaration of the rights and duties of certain actors and individuals to protect the basic human rights and freedoms of 1998, what we call the UN Declaration for the Protection of Civil Rights Defenders. So there are 4 chapters in this draft law. First, definitions and basic concepts. The second chapter, basic rights and obligations of the civil rights defenders on the protection of human rights. Chapter 3, the rights and obligations of the state actors and the government on the protection of human rights defenders. And chapter 4, it's provisions about the operations and performance of the national mechanism for the protection of human rights defenders. When this draft law was in progress, I would say it is still under development because we started since December and there was not enough time to prepare it very well. So when we were drafting this law, what grounds we found in our country, I mean, from legal perspective, this is the concept of the foreign policy of Kazakhstan for the years 2020-2030, adopted by the presidential decree on the March of 6, 2020, in which Kazakhstan is positioning as the responsible and active partner of international community, contributing to the regional stability, safety, and security, and
that seeks to develop the human rights domain. Also, this year, there will be 30 years anniversary of Kazakhstan membership in UN. Since 14 December 2021, Kazakhstan is part of the Human Rights Council as a chairperson, and also as of the 1st of September 2021, there is an address of the president who said that we shouldn't forget about the rights of human rights defenders, including lawyers, and that their security must be provided for and any illegal actions that impede their work have to be abolished. So there are some grounds for the law. Besides the international documents, so we have all the necessary basis to adopt the law in our republic. But we all remember the January unrest and all the democratic constructs, all this facade shattered. And therefore, we are moving towards such a law. We were moving towards such a law, but we stepped back and we actually turned our faces away from it. But in any case, even if our way is longer, but there should be a path towards our objective. And we have to remind our state that our state is a member of the international community, that human rights defenders play a very important role in the democratic society, that active participation of individuals and organizations really they're crucial for the continuous progress in achieving the international commitments, and the strong civil society helps the government to fulfill the rights and to move ahead. And the state has to understand that those different opinions have to be addressed in the peaceful way. And naturally, the government has to recognize the role of human rights defenders. So, along with the adoption of the law, along with various campaigns that were developed and are to be launched soon, I think that this is the right way to act. So the state's position on the law is quite clear. There is an analytical brief on the typical or model law for the recognition of the human rights defenders. of the Ministry of Justice of the Republic of Kazakhstan. So what is their position? They believe it's unreasonable to adopt a separate law on human rights defenders protection because there are no clear criteria of human rights defenders, that the rights of human rights defenders are already protected by other laws, and that the interpretation of international acts in the field of human rights is vague. So the position of the state is quite clear. So the draft law is there. And if you'd like to join its discussion and its amendment, let's arrange a group in Zoom to discuss each and every item of the law, to make amendments to the initial draft. I think we can arrange that. But the draft law is there already. Thank you.
Спасибо большое, Елена, за
Thank
презентацию.
you very much, Елена, for your presentation.
Будут ли вопросы
Are there any questions
спикеру?
to the speaker?
Поступил вопрос в чат от
There is a question in the chat box.
Бекова. А как можно с этим проектом закона ознакомиться?
How can we read this draft law? Anara, maybe you can respond to this. Thank you very much for showing your interest in this. That's what we expected. First of all, it's not just one person who worked on this draft law, because we have a coalition on the matters of human rights defenders protection. And on the 14th of December, the coalition for the human rights defenders protection law was created. We will post it in the BRKRPSH website petition section. You will be able to read it. And when we see the interest of the government agencies, we can arrange its discussion. So we are ready to do this anytime.
Спасибо большое. Еще вопросы от участников?
Thank you very much. Any other questions from participants?
Здесь в чат Анара Нурлыбаевна отправила ссылку на...
Anara Nurlibaevna sent the link to the website in the chat box. Madina, I have a question. This draft law.
Данный проект закона, который был разработан по правозащитникам, он планируется разрабатываться отдельным законом или же его планируют внести в какое-либо законодательство нашей Республики Казахстан?
Ерлан Капашевич, спасибо большое за вопрос. Это проект отдельного закона.
Да, ну дополнение вы дальше услышите. На самом деле идет пакет, это сам проект закона отдельный.
Package. It's a draft law, which is separate, but also amendments to the other laws. This will be covered by Evgeny Zhovtis. And also there is a comparative table that we are ready to suggest to all the government agencies on amendments and additions to the other laws and legislation. Alisher Kuzhagulov will talk about this. Yes, can you please send the comparative table as well? Yes, we will send all the participants these documents additionally immediately after the presentation.
Здесь еще один вопрос в чате от адвоката Эльмиры Жалмагамбетовой. Куда
Эльмира Жалмагамбетовна,
решение правозащитника?
she asks a question in the chat box. Where can we go to in case of violation of the human rights defenders' rights? Elmira, may I clarify your question? Do you mean today, or you mean the law, what is suggested in the draft law? I joined later. Apologies, maybe I missed something out. Recently, I had a case, you know it, when my lawyers' rights and my human defenders' rights were violated, and I didn't know where to go. So I called the prosecutor on duty. The telephone was silent. I called 102 line, no response. I called the human rights ombudsperson. So I had to apply to you, Kader Kassiet. You gave an advice to apply to the ombudsperson. So I didn't know what to do. Just to leave my clients. But being a person, humane person, I was standing there in freezing air for 4 or 5 hours, but I had to do something. Thank you very much. It's a very good question. It's one of the reasons why we need a new law. Because when the human rights defenders are left outside the legal framework, when the mechanisms should be available, they are not. Since 2014, we are having a dialogue with the National Center for Human Rights, chaired by the ombudsperson, Elvira Azimova. And several times together with Evgeny, we reported and we said that one of the ways out is to create a national mechanism for the human rights defenders that on the governmental level would help implementing the human rights activities, because the current activities, current mechanisms are not available.
В ходе январских событий, как раз когда омбудсман привлекала...
So the ombudsperson used to engage competent authorities of the highest level, like the Minister of Interior, General Prosecutor, and this worked. So this construct, such as focus or focal point, at this point is working already. But this must be somehow formalized. Maybe another alternative option could be the Commission on Human Rights, but given that this would be the advisory body that has no legal obligations to implement human rights functions, we need a body whose decisions will be mandatory for implementation. Therefore, we thought that the Human Rights Institute could be created under ombudsperson, given that the deputies of the parliaments and president supported the Senate's initiative and strengthened the functions of this national protection mechanism. So the national mechanism for human rights defenders protection would be good to create under the ombudsperson's office. And I'm sure that in all cases we could help, but today this issue is very relevant. And sooner the government does it, then sooner the human rights defenders would say thank you, because for us it's important to be effective. We, civil society, we don't want to waste our efforts. We need to see results, because we are trying to make our country better, so that our mechanisms inside the country work better and more effectively. Thank you. I understand that today, in this case, we have no place to go. In extreme cases, yes, the current mechanisms do not work effectively. Okay, thank you.
Спасибо большое за небольшую дискуссию.
Thank you very much for the small discussion.
Еще вопросы от коллег-участников?
Are there any questions from colleagues or participants? Ministry of Information and Societal Development. I'd like to ask a question.
Вашей сегодняшний анализ законодательства Республики Казахстан, препятствующего правозащитной деятельности. Я бы хотел услышать, какие законодательства нашей Республики Казахстан препятствуют правозащитной деятельности с обоснованиями.
Ерлан Кабашевич, спасибо за вопрос. Это как раз тема вопроса следующего спикера, Евгения Жовтис. Евгений Александрович, если можно, я вам так вот слово передам для вашего выступления дальше.
Доброе утро всем, спасибо. Я сейчас попробую на экран вывести свою презентацию.
Да, пожалуйста, можете сейчас
если получится. Угу. Так. Так, появилось?
Да, отлично, все видно.
Все, доброе утро еще раз всем.
Good morning, everyone. Before I start, let me say the following. Well, in the presentation, I will answer the question of the Minister of Information and Societal Development. The analysis is ready. You can read it. There are more than 130 pages, very detailed analysis. So, anticipating your questions, please keep in mind three things when we analyze the barriers for human rights defenders in the legislation. The first one, as we all know, the concept for human rights is the concept of relations between the government and people. Therefore, the human rights defenders promotes this concept, which is based on the range of principles and mechanisms written in international human rights treaties, which Kazakhstan ratified. So the human rights defenders promotes this concept, these principles, and also human rights defenders they protect certain victims of the human rights violation, whether it's because of legislation or because of practice. So the second problem, which was mentioned in the analytical brief of the Legislation Institute, is a problem of a definition of the human rights defender. It's not easy, but let me draw your attention to the fact that human rights defender definition is not about who, it's about what he or she does. So we rarely see professional human rights defenders. So people do not work in the international human rights defense organization. They don't do it professionally. They do it in order to fulfill their aspirations. And it's a question of what he or she does. If he or she promotes the human rights, like it's written in the declaration, then they are considered as human rights defenders. So there is a very thin line between the human rights defenders and civil rights activists. So it's very difficult to say who is the human rights defenders. So we have to see what they do. And if they do human rights activities, they have a right to protection. And also let me argue with the analytical brief, which says that we should need a law because there is no definition. I'd say a different thing. The laws adopted in the other countries, they are not to give human rights defenders some special authorities. No, these laws, they are about recognition of human rights defenders and their important work. And also, there should be some mechanism for their protection. These are two-fold objectives of the law. It gives a framework for the government to include into their legislation considerations about the importance of human rights defenders, whether it's political, civil, social, cultural rights. It's a set of rights. And there are different mechanisms that human rights defenders use. So analysis of legislation is quite big. And human rights defenders, they do something which overlaps with this civil activism. Therefore, there are areas where they act, and there are barriers in those areas. So it's not just about the legislation. So it's not like the human rights defenders activities are violated by the legislation per se. Well, we don't have a definition for the human rights defenders, but we, of course, all recognize the Declaration on Human Rights, but there are no special norms, but there are problems. Briefly, human rights defenders is the person who individually or together with others acts in order to promote, protect, and enforce the human rights and fundamental freedoms at local, national, regional, and international levels. Wide definition. So who are human rights defenders? So these are people who stand for the rights of people, activists in the field of human rights, lawyers, practitioners, legal counselors, barristers, journalists, and mass media promoting human rights, trade unions, activists. So this is a big number of people who are not professional human rights defenders. They are not working for HRD organization. They promote the human rights as activists, like ecological rights, Kokjai Liao. So they promote it. It means that he or she is a human rights defender because he or she is defending the rights for good environment. So you cannot make it a profession. It's a sphere of activities or objectives and goals of a person.
So here I indicated certain aspects relating to what the civil rights defenders are doing. You can read the UN Declaration, and it reads that every individual is entitled individually or collectively with others to incentivize and aspire to protect and exercise human rights, create associations. There is a freedom of association. Then support the communication with NGOs or other institutions. It is about the freedom of association. Now we have two things: freedom of association for human rights defenders. Next is seek, search, and retrieve and get access to information on the human rights. And this is how we talk about the access to information and right to information, access to freedom of media, and so on. And this is a wider range of different implications. Then to share information with others, discuss, have their own opinions on the protection of rights and freedoms, both in theory and in practice, engage the community, and use other means to promote. So this is about the expression of their opinion. Every individual is entitled to look for information, and this is what I meant. The right for peaceful activity, which is aiming to address the violation of human rights and freedoms. And here we're implying the obligations of the government, which undertakes all necessary measures to protect any individual from discrimination, from any violence, threat, reprisal, revenge, de facto and de jure, due to implementation or exercise of rights which are indicated in the declaration. So the declaration contains rights, and the government has a positive objective, an obligation to protect those civic right defenders' rights. So the government has a positive obligation to protect this. In this regard, every individual, which solely or collectively has a right for effective protection of the national legislation in case of any reciprocal measures or actions with the use of peaceful means against the actions or inaction the government is charged with resulting to the violation of human rights and basic freedoms. So it means that every civic activist and civic right defender has the same rights as any individual, with the only difference that the civic activists or civil rights defenders have a goal to protect the rights of the people. This is why here I also brought the obligations of the government in a very consolidated manner. The government should, and I think that it should be indicated in the model law. I mean, we would love to see it reading that the government should respect, protect, and meet the rights of the human rights defenders, facilitate the activity, provide free access to the materials, guarantee undisclosure of confidential source information, ensure protection from reprisals, and so on, ensure protection from arbitrarily or illegal interventions, assist in investigation, provide necessary safeguards and full indemnity, and recognize the reprisals as the violation of the human rights. And this is how the government should ensure effective procedures that the UN Declaration and the rights of the human rights defenders are protected, because these people, ordinary people, are protecting the human rights and freedoms as they are stated in the Universal Declaration of Human Rights. From this perspective, if you read this review, it is based on several sections with the analysis of the law on the protection against, on the fight against terrorism and other laws related to the national security, legislation on the right for, on the freedom for opinion, access to information, then legislation on the right for freedom of association, including the trade unions, and the protection of the human rights defenders. And my analysis is based on what I have already mentioned, but the remaining part you can, read at your spare time. So all this analysis is based in the comparison of the legislation of Kazakhstan and international standards or international provisions in international treaties for human rights, which Kazakhstan has acceded because of being members of certain organizations, be it OSCE or United Nations, and those treaties that Kazakhstan has ratified. And as Ms. McAvoy mentioned, the special rapporteur with a special procedure in place for quite a while, more than 10 plus years, I would say even 15, more than 15 years. And this rapporteur made a lot of recommendations presented to the UN Council for Human Rights, to which Kazakhstan is a member, and UN General Assembly. So this is a number of reports on the certain aspects of the civil rights defenders' work. But there is a special report I would like to inform you about, which served as the underlying document for the comparative analysis. It is a report by the special rapporteur on the protection of the human rights defenders, dated 2012, about the regulatory norms and problems of legislation on the civil rights defenders. And every section in our review start with the overview of these provisions, international provisions, just to explain what is there in place in the international arena and what Kazakhstan has and how this impedes the performance of the civil rights defenders. So the anti-terrorism law, I just highlighted major issues and like basic recommendations. Conclusions are very simple. There are many more, but I just put the most important ones. Problems of using the terrorism and extremism leader of public association, public activity, without proper legal certainty and predictability principles, and then additional restrictions which mismatch the standard of substantiation on the reasonable grounds and reasonable basis as part of list of individuals who finance terrorism. And it is not about the conclusion that we produce, but it is also reference to the other international norms, like the rapporteur on the issues related to the countering terrorism. And here you can see the highlights of the recommendations to fulfill the recommendations by the special rapporteur on the protection of human rights and basic freedoms in the context of fighting terrorism, resulting from her mission to Kazakhstan in 2019. Then to hold a review of the articles in the Criminal Code of Kazakhstan. And I know that the deputies of the lower chamber in Kazakhstan started discussing the legal responsibility for the extremist crimes based on the legal certainty and predictability, and based on criteria on the admissibility of the human rights limitations. And then determine certain additional punishments in certain articles of the criminal law related to the certain actions or inactions. So you can find the more details. Mr. Yevgeny, with your permission, can you go slower because our interpreters lag behind? Okay, the next part is legislation on the right of liberty of speech, expression of opinion, access and distribution of information. So I try to highlight from what I received from my counterparts, try to make review and put it into the recommendations, and make certain provisions on the promotion of certain rights and those laws related particularly on the freedom of speech, access to information, and so on. First, it is about access to information. It is a law which does not fully meet international standards related to the freedom of information and recommendations of international organizations, including OSCE, not necessarily only these international institutions, but many more. And there is a number of studies on this respect. Despite of decriminalization of the slander, it is not yet a part of the civil relationship, and then the insult is not yet decriminalized, especially with regard to the civil servants or high-level executives. Then legislation on the right to the freedom of speech, expression of opinion. So these are the major recommendations, and you can read many more in the review. It is about presumption of openness of information. It is a tri-component test of limitation of access to information, priority of the law on access to information against any other laws which govern the issues of information, and exclude automatic restriction of access to certain categories of information, then ensure full decriminalization of slander, insult, and similar charges which are envisaged in the criminal code, and then consider them in the civic proceedings, then to reconsider the law on the indemnity and moral compensation by identifying the direct causal link between the published information and reputational harm. So this is the part related to the human rights defenders activity. This is a wider section in the analysis, but this is a part, a bigger part, because by promoting the human rights, individuals may encounter the spread of the slander in the mass media, or access to information, or being made liable for promoting human rights for alleged violations of certain laws and legislation. So this is about number of laws which pertain to the protection of human rights defenders. Then law on the freedom of association, including the trade unions. So there are 3 organizational and legal forms of non-for-profit organizations. It is about the limited opportunity for individuals and other natural and legal entities to create organizations of civil society. And I understand due to certain events since recently, these issues are being postponed. It is about non-membership type of public associations, which we do not have yet legislated. Prohibition of the non-registered public organizations. This requirement does not meet international standards, and there is slow progress on amending this prohibition. The procedure of registration of public associations, which is very burdensome, and this has a discriminatory nature versus commercial organizations, and the law on trade unions does not meet the standards of International Labour Organization. Therefore, we need to introduce amendments to the law on the freedom of association, which also implies amendments to the laws on the non-for-profit organizations by determining the concept of the public association, which includes non-membership public association, having general criteria on its formation and management, taking into account that it has the non-for-profit business, then exclude founder and member from the legislation of Kazakhstan on the public and religious association by replacing them with certain initiators. Then to derogate the prohibition for the non-registered public association in Kazakhstan, exclude this provision from the law on public association, and then exclude from the law on administrative violations the administrative responsibility for creating or being part of non-registered group of citizens. So this is about the freedom of association. Freedom of peaceful assemblies. This has been repeatedly mentioned, and I would adhere to the same point of view, and I can refer to the experts in this domain. It is the expert in the OEC panel on the freedom of peaceful assemblies, and our law is still non-compliant with international standards, which is recognized by the International Bar Association and other renowned institutions. So other public activities as a concept has a very vague definition in this law on the right to freedom of peaceful assembly. The international standards of the individuals for peaceful assemblies are violated with regard to the stateless individuals, and holding meetings or conventions in the settlements are limited or prohibited with the unjustified grounds. Then there are also certain prohibitions with regard to the journalists attending these peaceful assemblies and other cultural activities. I'm sure that there will be many more proposals and improvements, and in order to avoid misunderstanding as part of the tragic event that we experienced, the law on the right to freedom of peaceful assembly is about the right to peaceful assembly. It's not about the violence or any riots and so on, because any counteraction to the mess and disorder should be addressed in a different way, because people who would love to attend the peaceful assembly do not entail any threat, and violence may happen, and we need to inform people of this implication regardless of the applicable law. We need to train the police and other law enforcement authorities that peaceful assembly is not trying to make a mess, but rather mess can result from attempts of other individuals who are joining the peaceful assemblies, but doing something wrong. And here you can see the number of recommendations. We can also follow the analysis. Let me move to the next. The law on the peaceful assembly should provide for the opportunity to hold spontaneous meetings, include the extensive list of activities in which the assemblies can be allowed. So the right for fair trial and effective safeguards, it is, about remedies, judicial remedies, and the applicable law of Kazakhstan does not contain this tool to protect their rights and freedoms, such as appeal to the higher Supreme Judicial Authority to protect the constitutional rights and freedoms, which is a big problem which needs to be addressed by expanding access to the Constitutional Council for the civic activists, civil rights defenders, or by restoring the special authorities. Then it is about the limited access of the lawyers and solicitors to the special state secrets. And the defendant has a right to select the lawyer. We had a similar situation in Russia, and by the court decision, this was cancelled. However, the lawyer, any defendant should have a lawyer, and the lawyers should have special licenses to perform their duties in a very high manner. And due to having a status of lawyer, they should have access to the respective state secrets to protect their defendant.
Also, the prosecution officers may abuse their powers. For instance, they may disclose a certain information, and this has been mentioned many times in the analysis. You can have a look. It's a very detailed analysis. Of course, the secrecy of investigation must be maintained, but at the same time, there should be a certain list of things which cannot be disclosed by the lawyers. For instance, if a person is beaten up or threatened, it's not subject to secrecy. Therefore, in the legislation, there should be a very good specification of what can and cannot be disclosed. Speaking of the guarantees provided by international treaties, so in Article 14 of the treaty, there are certain requirements, and so our legislation has a provision that the judicial ruling can or cannot be disclosed fully. So there should be an opportunity to apply to the Constitutional Council of Kazakhstan for the constitutional surveillance, and also we have to fulfill the recommendation of the special rapporteur of UN, and also we have to comply with the Article 29 of the Proceedings Code of Kazakhstan to meet the requirements of the International Treaty on Civil and Political Rights. The only exclusion, if this is about juvenile or matrimonial issues. Now, let's talk about the protection of human rights defenders. Our legislation doesn't have a definition of human rights defender, so there is no wide definition like what they do, and also there are no legislative, institutional, or practical guarantees for the uninterrupted and effective activities and protection of threats. And also, there is no legislation and no national mechanism for the human rights defenders protection. So we are suggesting to have the recommendations with the human rights organization in order to formulate and include the definition of human rights defenders in legislation, recognizing the important role they play according to declaration, and including the rights of human rights defenders in various areas. This is the element of recognition, issue of recognition. Then to adopt state strategy for the protection of human rights defenders so that they act in the safe environment, to eliminate any impediments they face, including women, children, LGBTA, disabled people. There should be mechanisms of periodic assessment of this mechanism. So we need to create the national mechanism on human rights defenders protection through several stages, like create a focal point, Human Rights Defense Council for effective feedback with the human rights defenders community, communications procedures, amendments and additions for the implementation of a declaration, and to resource the national mechanism for the human rights defenders protection. So it's just a question of a definition. This is activities that must be recognized, and there should be procedures to protect and for the effective feedback in extreme situations for the human rights defenders, as mentioned by the lawyer. So I'm about to finish. Thank you very much for your attention. Let me remind you one thing. Why is it important? Because, well, why other countries have laws on human rights defenders protection in Latin America, in Africa? Because human rights defenders are very vulnerable, because they raise issues of power abuse, human rights violations by the state. This is a very sensitive area, and sometimes, maybe not in state policy, but it may lead to a certain response or reaction from those who hold power towards this vulnerable group. But of course, human rights defenders' resources are incomparable with those the government have. Therefore, there should be mechanisms to provide for better protection of human rights defenders, understanding the importance of what they do. Thank you very much. I'm ready to take your questions.
Спасибо большое, Евгений Александрович.
Thank you very much, Evgeny.
Пожалуйста, можно сейчас задать вопрос.
It's time to ask questions.
Ирлан Капашевич, получили ли вы ответ на ваш вопрос?
Irlan Kapashevich, have you got answer to your question?
Да, я это прослушал презентацию Евгения Александровича. Там в основном это замечание касается нашего законодательства там, по адвокатской деятельности, мирное собрание, ассоциация и так далее. Вот, некоммерческие организации, которые сейчас действительно наше министерство занимается этим законопроектом. Согласно плану законопроектных работ, он включен на 2023 год. Поэтому будет создана дополнительно еще в ходе разработки будет создана рабочая группа, куда, соответственно, будут приглашены все заинтересованные некоммерческие организации. Я бы хотел узнать вот это дополнительно, вот это, то, что ранее адвокат озвучивала. Тут вопрос касается защиты правозащитников, вот, которые какое-то нарушение в отношении их со стороны государства или какого-то либо юридических лиц произошло. Вот, и они не могут обратиться к государственным органам за их защитой. Вот. Отсутствует защита препятствий правозащитной деятельности правозащитников. Вот. Поэтому я, как думаю, у нас существует закон о Генпрокуратуре, где Генеральная прокуратура и все органы прокуратуры следят за законной деятельностью, и они в случае нарушения они должны принять меры. Допустим, если не приняли заявление от граждан по нарушению их прав.
application or request was not taken by the law enforcement bodies, or if the courts have not taken the cases on. That's what I wanted to hear. So are there...
Ну, если можно, я попробую ответить на этот вопрос. Понимаете, дело в чем? Вы абсолютно правы, у государства есть целый ряд институтов, которые, как предполагается, в случае нарушения прав человека должны реагировать. Это, естественно, я добавлю, это и органы полиции.
Right. These are police bodies, General Prosecutor's Office, judicial system. This is true to any organization. But the point is that internationally in 1998, the declaration recognized that the human rights defenders are belonging to the category requiring special protection, requiring more effective response. Of course, all people have such a right, but human rights defenders as a vulnerable category need this to be more effective and pinpoint. Therefore, we are proposing to adopt a law and create a national mechanism for more effective response. And of course, this will reach the government agencies who have certain authorities. So it's about having more attention because of more vulnerability. So for this more vulnerable group, protecting human rights. Therefore, such laws are appearing in different countries, and the focal points are created, or special mechanisms, because of the importance of the activities they do. So this existing government mechanisms for the protection of human rights are strengthened vis-a-vis those who defend human rights. It was recognized on the international level. We can see what's written in the reports of the special rapporteur. You will see the analysis, and there is a section and answers to this question there.
Спасибо.
Thank you. Yes, we will read the draft law. We will see the comparative table. We have been working with Kadir Kasiyet in this area for a long time. For the human rights defenders protection, it's a very serious issue. And the representatives of NGOs, they say that, of course, we cannot do it overnight. There are different human rights defenders who protect the rights, but disguise the human rights protection, disguise their negative intentions towards the government by this human rights protection when they are not registered in our country. And as I know, there is a draft law on human rights ombudsperson. So the ombudsperson will have to defend human rights defenders. So this will be the mechanism to accept the complaints, pass them on to the law enforcement agencies, and follow-up monitoring, including participation in courts. And I think when this mechanism is used in our country, the human rights ombudsperson, therefore, this will then penetrate into all the areas throughout Kazakhstan. I think this will be enough for the human rights defenders protection. If I may, I'll respond. The point is, the definition of human rights defenders is much wider. It's not only initial legal assistance or providing legal services. Very often, human rights defenders are not lawyers, so they're not part of legal. So human rights defender has a wide definition. I mentioned already, and I know that the ministry is moving in the right direction. So we have to abolish this notion of registration for human rights defenders. Registration shall not be used for regulation. Registration is a technical procedure to get a legal entity status if needed. But if it's a person or group of persons, they could be human rights defenders in whatever way they want, besides the crimes, of course. What they cannot do according to criminal code, of course, they shouldn't. So ecological, political rights can be promoted by them. So it's not only a direct relation with the state, it could be indirect. People share information, they fix some facts. As you know, there is a law on public control being promoted in order to strengthen this component of public participation. So this is quite a wide area. And the main task of the government is to strictly monitor the compliance with the law, like criminal code, criminal proceedings code, and to create the conducive environment for the public participation, including encouragement and promotion of human rights. But at the same time, because of the sensitivity and vulnerability of human rights defenders, the government has to provide effective procedures for their protection if they come across the threats. Our ombudsperson, human rights ombudsperson, why such institute is very important, including NPM, National Preventive Mechanism. These are classical human rights defenders. It's about public visitations to prisons, to check the conditions, to prevent tortures. Why are they created? They did not exist before. They were created as the institute. And now we see that NPM is one of the most important mechanisms of public control in prisons or places of detention. And last year, the Ombudsperson's Institute was strengthened. It's a national structure which is not governmental. It's like governmental/public. There are various mechanisms strengthening the capacities of the society in terms of human rights protection. So adoption of a law is another step. And we need to understand that public participation is important in promotion of such rights, and limitations must be done only if there are real threats. So it's more about recognition and protection of human rights defenders. Thank you. Thank you, I heard you.
Спасибо большое за пояснение. Будут ли еще вопросы?
Thank you for these explanations. Any other questions? Hello. Good day.
Да, конечно.
May I? Yes, sure. Human rights defenders are promoting international standards in the field of human rights. This was mentioned, and it's true. There are international treaties, standards, but it's, of course, not a panacea for the problems we are seeing today. And development of 100 or 1,000 laws dedicated to the human rights activities will not resolve the main problem, will not fulfill the main task. And this is evidenced by this forum. We have lots of laws, pieces of legislation already existing. Let's develop another one. Of course, it's needed. These are necessary prerequisites, more public participation. Then more attention will be paid by the government to the problems, and the more they will amend different laws. And this will be a driving force. That is why we are here. So in my opinion, it's important to create the conditions in the national legislation of Kazakhstan. So let's be frank. Most violations of human rights, they happen in the prosecution offices, in investigation offices. Correct? Correct. If so, let's not lie to ourselves. Let's try to see the reasons. Today, the colleague from the Ministry of Information or the Ministry of Justice asked the question, what laws must be amended or improved? So there are very concrete proposals. Since 2004, I'm asking a question or different questions during different fora, like instigation of a case, pre-trial investigation, institute of the preliminary. For instance, there is a violation of the presumption of innocence, and there are changes. We have 3-star model now. Let me talk about it. Apologies, Mr. Nazmyshev. We will have a discussion time later. If you have a question on this session, please ask the questions, but we'll give you the floor later, okay? After the presentations of the speakers.
Do you have any question on the presentation by Mr. Evgeny? I don't have questions for the presentation, but I have some insights to share. Okay, we'll come back to you in the discussion after all the presentations are made, okay?
Да, спасибо, господин Назмышев.
Thank you so much, Mr. Izmyshev.
Если у участников нет вопросов, мы перейдем к
As we don't have many more questions, let's move to the last part of the agenda
коллегам. Здесь
today. And
Калеева, Алишер.
we have Tamara Kaleva, Alisher Kojagulov.
Тамара, как вы нас слышите?
To share their interventions. Tamara, are you there? Yes, I can hear you very well. Good day to all of you. In order to save time, I will not be talking about the deficiencies of the current law on media. Mr. Evgeny has mentioned a lot. We can talk for more and for longer, because we have been talking for this for a while, and the law is obsolete. But as to the agenda of the meeting today, I would like to mention that every civil rights defender, I mean, the majority of them are bloggers. I mean, their civil rights activity is covered through social media. And the concept of blogger is missing with the law. It should be defined. It should properly conceptualized. And since 2017, together with the Ministry of Information, we have been working on drafting the new law. First with Mr. Abayev, it was the law on the mass media. Then we were talking about the information code. And since recently, there is a working group which consists of international and national experts who collaborated with the ministry on the draft law on the mass media. And it was really embarrassing because it was dull and borrowing. The ministry staff wanted everything to be so confidential. We had some back and forth communications, and it didn't work. And the ministry suggested to legalize the definition of the blogger. And no matter how hard we work, I would like to talk about the prospects for the future. And you know, the events in January somehow put on hold this idea, but we are going to initiate it all over again together with the parliament, with the deputies, starting with the Ministry of Information, which we cannot avoid in any way. But we need to have a new code on the guarantee of freedom of speech. And this has been mentioned long ago by Mr. Altenberg Sarsenbaev, but of course this law is already out of date, but we need to have the applicable law that would be relevant for the civil rights defenders, bloggers, and this law would include provisions on the professional journalists, mass media, and it should be overarching law that would cover access to information, and it will be about the publicity and public disclosure of the trials and even the investigation stage. And this idea has already been shared, and we are going to work harder with the Ministry of Information and respective deputies to push this forward. And this is not only my opinion. We have been discussing in our expert community. It is only the code of guarantee of freedom of speech in Kazakhstan would be aligned with the new trends. It's like a new Kazakhstan with a new democratic legislation. Even this can serve as a motto or kind of logo, and we will keep working further on. Nothing from me. Thank you so much. And if you have questions, I'll happy to take them. Thank you.
Спасибо большое. Да-да-да, я
Thank
поняла.
you so much. Yeah, I see that
Теперь мы
you're done.
выслушаем оставшихся
Now
спикеров, и потом перейдем уже
we
к
have
вопросам-ответам и к
3
обсуждению.
more interventions, and we will continue with the discussions.
Сергею Молчанову,
Let me give the floor to Sergey Molchanov,
доктор СН.
who is the
Да.
representing the Public Foundation, Dr. SN. Good afternoon. We, as part of the National Preventive Mechanism, visited and following the January events. So we made an overview of the events in January. You know, we need to work harder on our legislation. You know, I'm a doctor, I'm a psychiatrist, and I'm the master of medicine, and the civil rights defenders are not necessarily lawyers. They do not necessarily have legal background. It is a wider circle of individuals which try to protect the rights of others. And my recommendation as a doctor is to amend the law to include the provision that allows NPM members to have access to the different institutions regardless of the emergency status or epidemiological situation. But to visit or not to visit the relevant institution in the circumstance of the epidemiological situation or other reasons is a right to exercise. And sometimes we try to visit the pre-trial detention facilities and they say, we have the lockdown, we have a quarantine, you cannot be allowed. And then the others allow us in. But the point is that we found that these 3 people, there were 3 people in this pre-trial detention facility under the national security charges. And regardless of the emergency status and regardless of the epidemiological situation, we should be possessing and exercising the right to visit any institutions under the law enforcement system. Also, we need to ensure that the ill prisoners or detainees will be treated in a good manner, so they are not isolated in the places which are not suitable for comfort stay, including their nutrition and so on, because this can be treated as a torture. Why this come to the agenda? We visited one of the prisons. It is a penitentiary facility, and according to the law, the administrative convicts shouldn't be there. And the emergency situation back in January highlighted those things which civil right defenders proposed but were ignored by the government agencies in terms of legislation. Then national preventive mechanism should be able to get access to the pretrial detention facilities, to prisons, including the premises of the national security, not only those administrative buildings. It's not a secret that sometimes people are being subjected to tortures in the basements of the National Security Committee buildings. And the force structures, such as National Security Authority, have their own secret or hidden structures across the country in which they can hide some detainees. And if we know what are they, and then we are allowed by law to enter these buildings, this will be a very good implication for the protection of human rights. In case of the emergency, the hotline numbers should be available for the public at large, so that they could inform about the illegal action or inaction or other wrongdoings by the law enforcement authorities. And because of January events, some of the family members didn't know about their relatives as to where their whereabouts. And there were some hotlines, but they were not fully functional. Also, we need to provide protection and lawyers to those who are allegedly committed some violations of the applicable laws. And there were cases when the defendants couldn't get their lawyers. There was a case when one of the defendants stayed in the pretrial detention, but then it was found that he was not actually participating in the meeting, but he was trying to just watch, to monitor the protection of human rights, so that the force authorities do not apply the unnecessary force. And the member of the National Preventive Mechanism back in summer, in the meeting of anti-vaxxers, was arrested, and she was put into the pre-trial detention, but and then she was released in 2 hours. But the point is that she had a vest with naming that she is just a monitor or she's just a journalist, but nobody cared, and the police put her behind the bars and then released with all other meeting participants. As we visit institutions in which people with tuberculosis can stay, or we visit the mass disorders, or when approaching the place of monitoring, the member of NPM broke her arm in the traffic accident. I mean, I put all my recommendations to Medina, and I would urge you to take a careful look on those, because these are, from my practical experience, are missing parts in the laws. Thank you so much for your attention. If you have any burning issues, I can answer. If not, then I guess Medina can take over. Thank you so much. Thank you much, Sergey. Indeed.
Следующее
You did a great job, and now the floor goes to
фонд развития парламентаризма.
Alisher Kozhagulov from Public Foundation Parliamentarism Development Fund. Good afternoon once again. In terms of the draft law on the recognition of the rights of civil rights defenders, this law is very conceptual, and it is pending. And along with that, we suggest to consider the associated draft law. It is about amending certain legislative acts of Kazakhstan on the recognition and protection of civil rights defenders. In an ideal world, in an ideal context, we should have this together, and whenever there is a working group under the ministry or the Majlis or a Senate, these laws should come together, and this should be accompanied by a comparative table. So we try to demonstrate the review by the experts, Mr. Kadyrov and Evgeny Zhovtis. So we try to make this draft law matching the template of the government authorities, like the structural element. The second column is the current reading. Third column is the proposed editing, and then comments or grounds as column number 5. So we work together with the experts, and of course we understand that there is an applicable law with the proper wording, and of course we propose our wording, and of course it will be many times edited because many different stakeholders can offer their own suggestions. But the idea is to have the context to make it clear that it's not amendment for the sake of amendment. It is about engaging the wider community, and we need to ensure that amendment is in place and it can lead to certain improvements. And having this comparative table prepared by January 31st this year, of course, we're looking forward for many other inputs from the respective stakeholders. In conclusion, I would like to add that there are many initiatives, there are many ideas from the civil society, very subject-specific or very conceptual, but in our intercourse, we shouldn't forget about engaging the public at large, civil society in the drafting of the law, in discussing the current applicable legislation and amending certain provisions and articles which raise concerns on the part of the civil society. And we also should remember that apart from having this law on the protection of civil rights defenders, there are issues related to the recognition and implementation of international recommendations, including different expertise, like examination in terms of corruption provisions and constitutional aspects to make our laws and regulations more compatible with the international law. And probably that's it from me. I have covered the major aspects, and some of them were previously highlighted. Thank you so much.
Спасибо, Алишер, за вашу презентацию.
Thank you, Alisher, for your presentation.
Два выступления.
We have two more interventions.
Общественное объединение «Право и справедливость».
Alexey Boshkov, Public Foundation Право and Справедливость, Right and Justice. Can I have your table, please? Okay. Working as a journalist and having some legal background, I have some recommendations which have repeatedly discussed with government authorities during different meetings, but no good. For more than 10 years, we have been talking about the limitation of action for the protection against claims related to the reputation and slander and so on. The point is that you can be summoned, but you do not remember because it was so long ago. And also, there should be a password there are judiciary acts which are secured with password, and whenever I try to get access to any of them, it seems that every judiciary act, every judiciary document is secured with password, and then you need to file a request, and then you need to go through the press service, which give a very breached information. Also, we need to strictly monitor on the performance of the law, which do not meet the provisions of the law on information. And every ministry or respective authorities have a press service and liaison officer. And then you find yourself in a situation that you file a complaint to the court because the respective government authority fails to meet the provisions. So they should have a proper staffing with the liaison officers or public relations office, and there is no way to get information from the ministry. Like in the pandemic, we didn't know what's going on in the East Kazakhstan Oblast, and when there was a disorder across the country in Kazakhstan, you didn't get any information about what's going on in the East Kazakhstan Oblast, and so we try to figure out what's going on and what we can do, how to respond, and so much closeness. So much unnecessary protection. And as for the defense lawyers, you can find a situation when the defense lawyer is assigned and he or she is doing nothing without objecting to the accusations or taking no position with regard to the defendant, like for sanctions. There was a high-profile case when the defense lawyer even agreed that the defendant should be under arrest, under confinement, and there should be a right to choose the defense lawyer rather than to assign forcefully a lawyer. And I would suggest it would be more efficient if it is the scope of work for the Ministry of the Justice. Let's say the lawyer or solicitor violates certain provision, then the complaint is filed to the Ministry of Justice, and then the Ministry of Justice investigates this particular case. So I think that this also should be supported by provisions. In the previous environmental code, there was a provision which allowed us to win a case on planting the trees if it was reasonably found to do so. But now no more. The this provision you can see in the environmental code. I think that this could be relevant for many aspects of our life. Presumption of innocence should be there in the tort law. And the point is that the prisoner is discharged and he or she needs to wait some time until his sentence to be cleared. And in terms of public associations, I would agree that we need to amend the law in full, but I found quite an interesting trick. The government agencies do not understand what is the freedom for the right for association of representative bodies. And the point is that the government does not understand when the person becomes a founder, but then becomes a member, and the membership can be expanded and they are not registered. However, they have the vote right to, let's say, close the association, but the government suggests that it should be the founders meeting to recognize the institution null and void. And the point is that it's rather difficult to find the founder. For instance, if you can be released from your post only when you find a replacement, does it mean that I stay as a founder of a public institution for my life? As for the Human Rights Commissioner, the current situation shows that the Human Rights Ombudsman should be a person from the civil rights system. So this person should be promoted by the civil rights community, and the Human Rights Ombudsman is too much bureaucratic, and this affects the performance. The national preventive mechanism needs reforms.
Why, until now, the national preventive mechanism visits the institutions only according to a pre-set list? Because people who approved the lists, they do not understand what is happening locally. The people who prepare the list for visitations, they don't agree it with the people who work locally. And it happens that some institutions which you don't need to visit because it's all ideally working there, it's visited every year. But there are institutions with lots of problems. They are visited seldom. So the national preventive mechanism must have a list of institutions and the members must decide, okay, we visited this institution long ago, let's go there today. Or maybe there is an institution which is working very well, so let's go see there. If it's okay, then we can visit it after some long period of time. So these are my recommendations that must be somehow reflected in the legislation or maybe somehow practiced. People are saying that the Ministry of Justice will impede the real human rights defenders. Well, this is possible. It's a very serious issue. So we have to make sure that all the issues related to lawyers or barristers to be solved in court so that they have a chance to protect them in courts. That's all from me.
Спасибо, Алексей. И сейчас последнее слово
Thank
хочу
you, Alexei. Let me give the floor to the last intervener.
чтобы Тесс могла поделиться примерами других
And
стран
Tess will share the examples of other countries,
над принятием закона о национальном механизме.
examples of adopting a law on the national mechanism for human rights defenders.
For me now, the translation was a bit slow. Okay, so I just wanted to come in briefly, I think, to thank the other speakers for all of the information that's coming through. And it's really clear that there is a clear call that the legislative framework in the country can be strengthened. I wanted to echo some points that came through from some of the other speakers that were talking about the risks of registration. And so just to really confirm here that where there have been any developments at the national level that have included registration that has been a very concerning, and that is in those situations there have been clear calls made on the government from the international human rights mechanisms and institutions, because those registration systems can be used to restrict the rights of human rights defenders. And as has been said today, that definition of who is a human rights defender is focused on the work they are doing. Anyone who is working to promote or protect the rights of others is a human rights defender, whether they are doing so professionally, whether they are doing so voluntarily. That is a very broad spectrum, and everyone should have these fundamental human rights to the right of expression, no matter whether, as long as they're promoting the rights of others, whether or not it can be critical of certain violations that are taking place, whether that be by the government or non-government entities or businesses. Everyone has that right to freedom of expression and to promote the rights of others. So really just to emphasize the other comments that were made today and welcome those, and really highlight that risk of not creating registrations for defenders because that is seen as a way of restricting their rights, and taking the broadest possible definition of defenders. So another thing I wanted to note was that, we're talking a lot about looking at the legal framework, but that is only, one element of the protection for defenders that's needed. But in saying that it's one element, it's one critical element that's needed for the protection of defenders to ensure that other human rights can be protected, and to ensure that there is a safe, enabling environment for their work, and to support the rule of law and to support democracy. Other areas, as I mentioned when I was speaking before, are necessary, but it's really critical that there are rights protected in law, and that the state has an obligation to protect them, and that there are ways in which procedures to follow in the event that the rights of human rights defenders have been violated. And to echo again what has been said previously, these are not creating new rights. These are rights for everyone. They're fundamental rights that are needed for defenders to do the work that they're doing. So I mentioned before that we have seen progress in various different countries. In West Africa, there has been progress in laws being developed for the protection of defenders, which really set out the rights and recognize the work that defenders are doing, and acknowledgement by the government of the work that are doing, and also an imposition of sanctions where rights of defenders are violated. There was a law recently adopted in Mongolia just recently that the initial draft did follow the model law draft, that's looking at the recognition but also the protection of human rights defenders, and also developing a protection mechanism for the protection of defenders in the event that their rights are violated. And throughout Latin America also, there are various protection mechanisms and laws that have also been developed and passed, and some more new and some old, that are looking towards the protection of human rights defenders. And each of these vary depending on the national situation, but ideally all of them, they seek clearly and set out the rights of defenders to be protected, the responsibilities of both state and non-state actors to protect them, and that they don't place additional limitations on defenders, and that they're in line with international human rights law. And again, that was what we were seeking to do with the model law, was to kind of try and articulate the international human rights framework to be articulated at the national level. So I'll stop there and just say that we're here to continue this conversation and welcome all of the work that has been done and is continuing to be done by partners here.
Спасибо большое, Тесс.
Thank you very much, Tess.
И к обсуждению
Dear participants,
здесь присутствуют представители государственных
we have representatives of government agencies here for
комментариев.
the discussion session.
Передаю вам слово.
Let me give the floor to you.
Господин Назмышев, у вас были комментарии, вы можете сейчас их проговорить, пожалуйста.
Mr. Lazmishev, you had some comments. Once again, hello, dear colleagues. Let me repeat briefly. What are we talking about today? We are talking about consequences and such issues as tortures. Unfortunately, they're still taking place. Therefore, I have the following suggestion. Given that some negative events they happen during the pre-trial stage, during prosecution, and they violate the principle of presumption of innocence. Let's start with it. The point is, in the Constitution, Article 177, Part 3, Item 1, there is a principle of presumption of innocence. But Part 4 of this article, so it talks about this principle penetration into all pieces of legislation and enforcement. So this Part 4 says that it must be used by all courts in the Republic of Kazakhstan. So it's personified. So it's like it's not for pre-trial, but for courts only. And this is a contradiction. So it looks like the person can be said guilty before court, which shouldn't take place. So in the indictment, they write that the guilt was proven fully. So it means that the person was considered guilty. So the prosecution officers and indictment officers, it's their main goal, which violates the article on the free, on the correct and on the all-round investigation. And the investigative judge has certain functions which are not reflected in the codes of criminal proceedings. Unfortunately, we cannot hear you well, Rahmadi. Can you hear me now? Yes, we can hear you now. Could you please repeat what you said? Let me repeat. So there are violations of the legality on this pretrial stage leading to tortures and violation of rights of people. I believe that it's because of how the national legislation determines the mechanism of implementation of the presumption of innocence principle. So it's the way it's written in Article 177, Part 3, Paragraph 1. You know that this principle is there, but Part 4, well, we have recording, so we heard you okay. So maybe you shouldn't repeat. I heard you well. Okay. So let me continue. It would be reasonable, given that the innocence, so the guilt of person is subject to the court, so the person shall be considered guilty only after the court ruling is enforced. So it's only about the indictment or ruling of the court. But other decisions of the court, it's not mentioned at all. So it's a flaw. And the main problem is, So many lawyers think in the same way, and I think in the same way. This principle must be taken out of this article of the Constitution and transferred to the second section that talks about protection of main rights and freedoms of a person. And a person must be considered guilty only after the enforcement of the court ruling, court decision. And preliminary guilt is not permissible. And this must be translated to all the stages of the process. So speaking of the Criminal Procedures Code of Kazakhstan, you know that we have three-star model. There is a draft law on distribution of responsibilities between law enforcement, prosecutor's office, and courts.
Уважаемый господин Назмышев, я вам хочу...
Dear Mr. Nazmyshev,
Вы не могли бы ускориться? У нас время подходит к
could you
концу.
please speed up because we have to finish? So I believe that in Criminal Procedures Code we need changes. There is no mechanism for implementation of certain principles. We need a norm saying that all principles of criminal process have to be equal, and violation of any principle is a significant violation of criminal proceedings legislation, and the evidence obtained in this way are impermissible, and this must be written in this way. And also there should be allocation of functions in criminal proceeding code specifying the following. Article 113 has to be amended, like conditions of proving the guilt. They must be equal on the pre-trial and trial stage, but these are two different stages. So the guilt can be established on both stages, but it's impermissible. Once we address it, then we'll talk about three-star model. This will solve many problems. The last point, speaking of extremism, today we can talk about extremism in any sphere, consumers extremism. So any critics could be considered extremism. And there are sections, units to counteract extremism. And if such units exist, there should be KPIs for them. Otherwise, they will find guilt where it does not exist. This norm on extremism should be decriminalized. Thank you.
Спасибо, господин Назмышев.
Thank you, Mr. Nazmyshev.
Уважаемые участники, коллеги, у
Dear
нас
participants, dear
презентация
colleagues,
подходит к концу. Я прошу
it's
тех, кто
time
хочет
to wrap up.
поучаствовать в обсуждении, пожалуйста, можете это сделать сейчас.
But if you'd like to participate in discussion, you can do it now. Madina, could you please read the statement of Musagali, the disabled person advocate who protects the rights of disabled people to participate in elections?
Мусагали
Давылов.
Это один из правозащитников с
He's one of the human rights defenders,
который
defending disabled people's rights.
в мероприятиях
He participated at our events.
заявление, где он говорит о том, что его право на участие в
And
выборах
he says that this right to participate in elections is limited. Madina, we are losing your sound.
Как меня слышно сейчас? Я
What
только
about
что
now?
сказала, что Мусагали Даулов – это правозащитник с инвалидностью.
Musagali Dawilov, human rights defender,
Нам заявил
defending
о том, что
disabled people.
право на участие в выборах было
He
нарушено.
said that his right to participate in elections was limited, was violated. Unfortunately, the sound is very bad. Dear colleagues, what about the other people? Can you hear Madina well? No, I couldn't hear her either. So let me say what we'd like to point out, because the right of access to voting for human rights defenders and disabled people is very important. Musakali Dawilov is the person with a sight disability. He said that there was no special paper for blind people, and this prevented him from voting. So it's a question to the Central Election Commission why such special paper was not provided. And so he's proposing changes to legislation on elections. But as you know, dear participants, experts, partners, there could be many proposals like that. And today we announce that we are collecting such proposals to add them to the comparative table. And Mr. Zhovtis made an analysis. And of course, it doesn't concede, it does not says that it's exhaustive. So let me check once again. We are announcing the call for proposals. Please provide your suggestions. We do it. So it was presented by Kashagolov Alisher on the voluntary basis. If government agencies have any initiative or interest to discuss it, we are ready to arrange a discussion with the civil society, but with the independent civil society. So we are ready to have any initiatives organized in order to promote adoption of the law on the national mechanism for human rights defenders. Let me once again talk to government agencies. Do you have anything to say now? We are ready to take your point. I don't see any hands raised, so probably today we don't have comments from the government. But let me remind you that the president on 9th of June last year signed a decree on the plan of priority measures in the field of human rights. It means that our rights for public control to follow up on the legislation enforcement. By the way, the government have to follow the document signed by the president. Let me remind you of the deadlines. Because this order, this decree was adopted with the following action plan. So the deadline was 25th of January, but we haven't heard about any implementation. So we'd like to talk to government agencies. Could you please publicly post the information on the websites, like the Ministry of Information, Societal Development, Ombudsperson's website, so that more people, the civil society, know about the measures taken, what is the stage of discussion about the national mechanism for human rights defenders protection, and we are ready to take part in the discussions. Anyone willing to say anything? I don't see hands raised. Thank you very much for your attention. We are closing our discussion. But we'll send you all the documents, including a comparative table. So please visit our website of Kadir Kasiyet, and at berkerpesh.kz there will be a post with the text of the draft law we are going to amend. Thank you very much and goodbye.